and welcome to the Burr Broadcast, where we provide you with important legal updates on the latest labor and employment news. My name is Gabriell Jeffreys, and I am an associate in Burr & Forman's Birmingham office. Today, we're going to be discussing the Pregnant Workers Fairness Act. As many of you recall, the Pregnant Workers Fairness Act went into effect last June, and it requires employers to provide reasonable accommodations to the known limitations of a qualified employee related to pregnancy, childbirth, or related medical conditions. Today, we wanted to talk about the PWFA because just last month, the EEOC issued its final regulations implementing the Act. Now, many of you are familiar with the reasonable accommodation requirements under the ADA. The final regulations implementing the PWFA really highlight some of the differences between these two statutes, and I wanted to cover just a couple of those today. So first, one of the biggest differences between the two is who is a qualified individual. Under the ADA, employees must be able to perform the essential functions of their job with or without accommodation to be a qualified individual. Under the PWFA, it is very different. Qualified employees include those who cannot perform an essential function for a temporary period if the person is expected to be able to perform the essential function in the near future and the inability to perform the essential function can be reasonably accommodated. The important thing to note about the difference between these two is that the temporary suspension of one or more essential functions may be a reasonable accommodation under the PWFA, which is extremely different from the ADA. The second difference I wanted to highlight today is the conditions covered by both statutes. The ADA only required accommodation of pregnancy-related conditions that cause a physical or mental impairment that substantially limits a major life activity. Under the PWFA, pregnancy-related medical conditions do not have to rise to the level of an ADA-covered disability to be covered. Instead, conditions covered by the PWFA can be minor, modest, or episodic. The PWFA covers healthy, uncomplicated pregnancies as well. In addition to pregnancy, it also covers childbirth or related medical conditions. Related medical conditions is the one that we have seen the most questions about so far. You may be asking yourself, well, what is considered a related medical condition? In the final regulations, the EEOC included an expansive list of potentially covered conditions, including conditions such as gestational diabetes, high blood pressure, nausea and vomiting, endometriosis, dehydration, and more, just to name a few. The third difference I wanted to highlight is the difference between what documentation employers can request. Under the ADA, when the need for accommodation is not obvious, employers may request documentation about the individual's disability and functional limitations. Under the PWFA, employers are significantly more limited in the documentation they may request. Specifically, employers may only request documentation when it is reasonable to do so. And the regulations have even identified 4 scenarios where the EEOC says requesting documentation is not reasonable. These include, number 1, when the known limitation and need for a change at work are obvious and the employee provides self-confirmation. Number 2, when the employer already has sufficient information about the limitation and change needed. Number 3, when the employee is pregnant and seeks one of the predictable assessments identified by the EEOC in the regulations. These 4 predictable assessments are carrying water, additional restroom breaks, sitting or standing, or breaks to eat and drink. 4, when the accommodation is related to lactation or pumping and the employee provides self-confirmation. And 5, when the requested accommodation is available to employees pursuant to an employer's policies without submitting supporting documentation. Today, I've highlighted only 3 of the differences between the Pregnant Workers Fairness Act and the ADA that we have learned from the regulations. But remember, there are numerous other differences between the 2 acts and many nuances where the Pregnant Workers Fairness Act is concerned. So we encourage you as employers to stay up to date on these regulations as well as any new developments in the law. If you have questions regarding these topics, please do not hesitate to reach out to Burr & Forman's Labor and Employment Group. Our team is always prepared to help you navigate these issues. Visit us today at www.burr.com.